All right, the last case of the morning will be Davis versus Florida Department of Corrections.
Happy now. Don't do that.
How much time would you like for rebuttal?
5 minutes or whatever remains if it's more than 5 minutes, if that's all right.
All right, you may proceed.
May it please the court. My name is Shayna Thorpe of Thorpe Law, PA, formerly Thorpe & Thorpe, PA, and I'm here today on behalf of the appellant, Rhonda Davis. This case should be reversed and remanded without delay. The circuit court judge improperly granted summary judgment for the defendant in this case, the Department of Corrections. In doing so, the circuit court judge made determinations of credibility on issues of causation in particular, and also erred in holding that Ms. Davis failed to exhaust her administrative remedies. The order in this case is almost 100%, in fact 100%, taken from the summary judgment provided by the defendant, and it includes incorrect information and incorrect standards of law.
All right, why don't you really focus on the exhaustion of administrative remedies? Would you agree there was no timely complaint made with the EEOC for the retaliation?
I would say that sort of, because the complaint where the box was checked saying retaliation was not filed within the 365 days of the termination. So that is correct in a sense. Our position is that the retaliation claim grows out of, or could reasonably be expected to grow out of, the timely charge concerning the discrimination which was filed on August 17th, 2013. And that's evidenced by the comment that was included in the course of the investigation by Ms. Davis, where she specifically said, and this is in Bates record on appeal number 439 to 440, she said, "I returned to work on August 20th, 2013, and told Warden Tina Roberts about the charge, and 2 days later I was terminated." Now this was to the EEOC investigator, so plainly there was not only a theoretical arising from the charge of discrimination, but an actual opportunity for the EEOC to investigate. And that is the crux of the issue here. The defendant wants to get very specific in terms of holding Ms. Davis to a very technical reading of the administrative prerequisites, but the courts have not sustained that. The courts have repeatedly said that this technical requirement should not bar people from obtaining relief. And that's why this reasonably grows out of language is used, because the idea is the EEOC should have the opportunity to investigate, conciliate, and perform its function before lawsuits are initiated. And the EEOC had full and fair opportunity to do that in this case. I also provided the court, and I understand it was late last night, with supplemental authority that was entered in May of 2019, so following this briefs. And that case is Baskerville versus Secretary of the Department of Veteran Affairs, 377 Fed Sup 2nd, 1331.
But in that case, there had been a retaliation complaint filed with the EEOC, but it listed like 3 things, but it didn't list the firing, but it listed retaliation as far as other adverse actions taken against the employee, and a reference specifically, and then I was fired. But, I mean, retaliation was made the subject of a complaint. The issue was, okay, you mentioned 3 items of retaliation, but you didn't mention the 4th, was kind of the argument made by the defense. it wasn't a situation where there was no retaliation claim at all filed with the EEOC. Would you agree with that?
Yes, the case says what it says, so I can't dispute that. But what I would say is the interpretation of that has two very important ramifications here. First of all, the defendant has argued, and the court adopted via its order, this incorrect reading of the Morgan case, a Supreme Court case about continuing violations versus discrete acts. And what Your Honor just indicated in the Baskerville case is very important because it talks about discrete acts of retaliation, right? We have the multiple acts beforehand, and then we have the termination, which did not have to have a separate charge of discrimination. So what that says to us is that that discrete act of the termination is not in this continuing violation theory, and it does not require a separate charge. So the analysis in that case did not hinge on the fact that there were other retaliation claims. This was just another form of retaliation. That was not the analysis. It was the issue of whether it happened before or after the charge was filed. And the second issue that is important in that case is that the Baskerville court rejected, and I'm going to say it wrong, but I'm going to try, the Duble case, D-U-B-L-E, and that's the case that the defendant really hung its hat on here. And the issue is that the contents of the charge brought the issue into the EEOC's purview. What the court noted was that Duble is, whether it works or not, is not a binding precedent. And by that I mean very specifically that Duble was a non-published 11th Circuit case. And in the absence of publication, the previous cases stand. So in this case, and there's an example of that, in Julius v. Johnson, 755 Fed 2nd 1403 of the 11th Circuit in 1985, the court said one panel of this circuit cannot overrule another panel's decision. That can only be done by this court sitting en banc or by the United States Supreme Court. And Duble came out unpublished by a separate panel after numerous 11th Circuit cases that were cited in the briefs addressing this very issue of the administrative prerequisites, including, for example, EEOC versus Reichhold Chemicals, 700 Fed Sup 524, 1988. That was a published case. Baker is addressed. A number of cases that say they're extremely reluctant to allow procedural technicalities to bar claims brought under Title VII. And when I say binding, I want to be clear because this was made in the the appellee answer brief. I don't mean to say that 11th Circuit cases are 100% binding on state courts. They are persuasive authority. However, as the court is aware, the Florida Civil Rights Act is interpreted consistently with Title VII, and that's where I would bring in this argument on that.
The third DCA has an opinion, I don't know how to pronounce it, B-U-A-D-E, which is very similar to this case, but they make the statement that retaliation is an entirely separate cause of action from a discrimination claim. Would you agree or disagree with that?
I would agree with that. That is certainly a different issue. You have discrimination based, in this case, on race, which was the original charge brought, and then you have retaliation. They are two very distinct issues. However, it does not take away from the idea of a charge growing out, or the idea of a retaliation claim growing out. In fact, filing an EEOC charge or an FCHR charge is a de facto, in fact, de jure, protected activity. That is one of the primary ways that people become protected under the Florida Civil Rights Act. And so it's almost intrinsic in that retaliation is likely to result, could result, is likely to flow. And multiple courts have said it would just be an exercise in duplicative behavior to file another charge. In this case...
Like the Gupta exception, you had a discrimination claim filed with the EEOC, but the retaliation claim was not. But then the plaintiff filed a two-count complaint, discrimination and retaliation, and the defense argued you can't proceed on retaliation, you didn't file a timely claim. And they said, they referred to ancillary jurisdiction. So you got the discrimination claim, so as long as the court already has jurisdiction of that, it can also consider the retaliation claim. But then there's a couple of the unpublished 11th Circuit opinions which say But if you don't have the discrimination claim, then that exception doesn't apply. What's your response to that?
Originally, the discrimination claim was brought, and for reasons, just legal decision-making process, that was not pursued, not because we didn't think it had merit, but we wanted to stick with, we believe, the strongest claim and limit the issues to the most precise we could. And so, in this case, the charge of discrimination, yes, dealt with the discrimination, yes, originally was there, but that does not mean that the retaliation which grew out of that charge necessarily is beyond the purview of the court. Just because they happen to go hand in hand most of the time in litigation, I don't read anything that says that they have to. Those typically are the circumstances that Your Honor addressed in those cases, and that is usually what happens. But in this case, the strategic decision was made not to follow that path. Beyond that, I think I want to make clear that there is a disputed issue of material fact as to what was quote-unquote contemplated in this case, and it's a credibility determination. What we don't know is what the plan was with respect to Ms. Davis before she left on leave, her FMLA leave in July 1st of 2013. It's been argued, certainly by opposing counsel, that there was a decision to terminate that was made, or possibly terminate, but if the court were to look at pages 385, 386, and 384 of the record, the letters don't say anything about you are going to be terminated. In fact, at page 386, which is the first letter of July 1st, it says, "You will be permitted to submit relevant information, orally or in writing, or both, including witness statements in the form of affidavits. A final decision will not be rendered until all facts are carefully considered. You will be advised at the conclusion of the conference when we will decide whether or not to take disciplinary action against you." And again, it's when we will decide, not that we have decided or we're thinking about deciding. And one thing that is articulated in the briefs, and certainly was at the hearing, is that there's a Florida Administrative Code provision that allows for a panoply of potential disciplinary actions, from written reprimands to termination. It's any number of things that could have happened. So we don't know for sure that termination was at issue. Furthermore, if we go to page 384, which is the July 9th letter, it does not say, oh, we're retracting the July 1st letter and we're going to terminate you straight away because you don't have a right to a predetermination conference. It just says, this is to inform you that the Permanent Career Service Predetermination Conference letter, dated July 1st, 2013, and mailed to you via certified mail, is being rescinded. You are currently in probationary status as a chaplain. Now, that letter could have said it's being rescinded because, by the way, you are probationary, and so we don't have to have a predetermination conference. We're just going to go ahead and fire you. It's not what it said. It's not what it said. And as we know in statutory construction, for example, the absence is presumed to be intentional. Certainly, the Department of Corrections could have included language to that effect. And so I think the issue here is what was contemplated. For example, Warden Roberts could have had in her mind that she was going to issue a written reprimand to Ms. Davis, and that's what was coming about. But then, when Ms. Davis came back on August, I believe it was 19th, and advised her, hey, by the way, you should be aware that I filed a charge of discrimination, maybe then Ms. Roberts came and said, well, I was going to issue a written reprimand, but now I'm going to go ahead and fire her because I don't like this charge idea. What we do know is that there's conflict in the evidence. We know that because we have Warden Roberts' affidavit, where she says, yes, we were going to terminate. That was a decision. We just didn't do it because we have a policy that says not to do that when someone's on leave. We have not seen that policy. That's just Warden Roberts' word on the subject. Okay? We then have Ms. Davis's word that she had a meeting with Warden Roberts on August 19th, where I believe the words used by Ms. Davis were that Warden Roberts stated, Trevino, the previous warden, is gone. Don't worry about it. We got a good team, and we're going to shine. So it could very well be inferred by a juror that the decision, whatever it may have been or thought of, was off the table. That for whatever reason, it had been pulled back, and we were going to go forward. And that was what is being said. Now, again, that's conflicting evidence in terms of testimony. We also add to that the letters and what they say and what they don't say. And what we end up with is a credibility determination. Do we believe Warden Roberts when she said, I was going to terminate? Do we believe Warden Roberts later when she certainly seems to indicate that whatever was happening before is gone and done, and we're going to move forward now? I mean, certainly Warden Roberts could have said to Miss Davis when she came back to work on the 19th, don't bother sitting at your desk, don't get all set up, because we decided to terminate you. Now, mind you, I would also add that a predetermination conference is a 14th Amendment due process right, and even though Ms. Davis did not have a right to that as a probationary employee, that did not mean that it could not have voluntarily been provided. So certainly there was an opportunity to challenge this or discuss it if that was what was desired, but it was just revoked. So in conclusion, at this time, unless there's rebuttal needed, I would request that the court reverse and remand to the circuit court so that a jury can properly weigh the facts, including those of causation. And I would ask that this court hold consistently with Baskerville, that the charge grew into the retaliation claim, which happened again by virtue of Ms. Davis's statement during the investigation process by the EEOC.
All right,
Thank you.
May it please the court, Thomas M. Gonzalez for the appellee. And Your Honor, I would like to begin with the exhaustion issue and speak to that first. And I think it's important in framing that issue and looking at it that the course of this case and the way it developed and how it was filed and litigated is important, because I want to begin with the fact that there was only a single count complaint filed against this defendant. There has never been a claim of discrimination filed in court, never been pursued. And I believe that is the first indicator of the fact that the retaliation count that is attempting to be pursued now was in fact something that was separate and distinct, and that no timely charge was ever filed with respect to it. And the second thing that I think is important is that there was in fact a charge filed alleging retaliation. So the plaintiff obviously believed it to be a separate event, because they took the trouble much later down the road and after all the time had run, but they in fact made that charge and alleged the retaliation and only that retaliation. The fact is undisputed that in this context, the only charge that was filed, the first charge that was filed, was a charge that only alleged discrimination based on race. It had occurred months after the plaintiff had received notification that there had been a decision made to recommend her termination. And I pause there to note that while the plaintiff, who I believe has attempted to argue facts in different orders at different times in the course of this case as reflected in the record, but what is absolutely clear is that in terms of focusing on a claim of discrimination or retaliation, it is an intent crime. And what is important is what the decision maker had in mind and what the decision maker was doing. And the decision maker in this case clearly was the warden, who was testified to by the plaintiff as someone that the plaintiff always got along with. And there is no question, and it is undisputed, that the warden testified without any kind of contradiction that she made the decision to terminate the plaintiff, to recommend her termination. Her decision to recommend that she be terminated. And the record also contains the status of the plaintiff at the time, and that is the reason that she was with this warden and had only been there since April, a couple of months, was that she had taken a voluntary demotion and was on probation, and the record has the proof that she was reminded of that probation when she came to this facility.
Let me ask you,
Yes, sir.
was the discrimination claim, did they exhaust their administrative remedy as to that claim?
Yes, sir.
And then what was the result? We don't know?
No, sir, the result is you don't have to let the EOC finish the investigation, so you exhausted by filing it.
Okay.
And with respect to a determination, there's nothing in the record that a determination was made, and I can tell the court that, as a matter of law, there's nothing wrong with a plaintiff deciding to file suit after 180 days and that kind of stuff, but no, sir, there's none of that.
Okay.
But clearly there was exhaustion on the race claims.
The other thing that was interesting to me, I mean, I was looking at from a pleading point of view, your side didn't raise that as an affirmative defense. Usually that's an affirmative defense, isn't it? Failure to exhaust your administrative remedies. I mean, I think it was tried, there's no question, but just in the pleading, they said we comply with all conditions preceding. I think they said including the administrative. You denied that.
Your Honor, and I'll be glad to answer the question, and I think I'm going to have to take you off the record a little bit, although they are matters of record, but this case began as a suit in federal court.
Oh, okay.
And then was remanded to state court.
Okay.
And with respect to the issue, the law allows you to file a lawsuit under Title VII within 90 days of your receipt of a notice of right to sue.
Okay.
With respect to the state Florida Civil Rights Act,
Right.
you have to file a charge within a year.
Okay.
That's an administrative prerequisite.
Okay.
But you have the right to file a lawsuit within the 4-year statute of limitations.
Okay.
So when the federal court remanded this case, it remanded it with the order saying the dismissal is granted as to everything that the state has raised, with the exception is I'm going to allow remand on the retaliation count, and I'm going to allow that to go forward based under state law only.
Okay.
So at the time that it came back to the state court, there was no need for a defense because it was timely.
Oh, okay.
And Your Honor, at that time, not now, but at that time, there was in fact the ability, the same ability she had to file this retaliation claim, she could have filed the discrimination claim under the state law. But she's never chosen to do that in federal or state court. And that's where we get back to the fact that when you're talking about the issue in terms of what was before the EEOC, then it's, I think, just crystal clear that these were always separate events. And I think that the supplemental authority that was submitted was, and I got it on the way over here, so I don't have the name at my recall, but the case that this morning was supplemented makes the very point. And that is, that was a case where there was a charge of retaliation. And there was a charge of retaliation in terms of what was going to happen with respect to that particular case. And the court noted that it was amended twice to add different events of retaliation. And finally, was amended to add the discharge, and the court rightly so said, well, no, this clearly that if you were alleging retaliation, but that the analysis itself, Your Honor, we believe proves that what we've been saying, and that is that's how those cases are approached. Those cases are approached on what's presented, and in this case, the charge that needed to be filed within 356 days for purposes of the state statute in terms of exhausting administrative remedies, then this was a case where clearly there was nothing that would put them on notice. And when the...
Let me ask you, in this case, in light most favorable to Ms. Davis, what did she got the letter, the EOC letter of some kind that came to her that she gave to the superintendent, right? That's what happened?
That's what she testifies to, yes, sir.
I filed an EEOC claim. She thought the letter was for the superintendent, it really was for her, but...
Yeah.
And then, a week later she got fired, right, or whatever? Or she got terminated?
No, a day or so after that.
A day, so I mean, it seems like, well, from their point of view, that could be connected. You know, I filed a claim and I got terminated.
I agree, Your Honor, and that gets us into the whole issue of the summary judgment and why it's appropriate in the timeline and why it's important when you're reviewing the record and the arguments that have been made. We believe there's been differing letters. First of all, with respect to the issue of when the warden saw the letter in terms of what was going on, there's never been a dispute, but that the warden had knowledge of the charge before the termination letter was sent. There's a dispute because the warden doesn't remember anything about getting it from the plaintiff, but she certainly got it in the course of the House mail. And in any event, though, from the time...
Your theory is that she'd already decided long before that.
Yes, sir.
I understand that.
And there's nothing in the record that would allow any inference that any action was taken by the warden between her receipt.
It seems to me you could, that may be iffy.
Okay, Judge.
I'm just thinking.
I understand, but and clearly the standard is de novo, and I understand that.
Yeah, right.
But
you
with
agree
respect to the
that if the warden had decided in her mind, I'm going to fire the chaplain, and I'm going to wait till she gets back from leave. And then she gets back from leave, and the warden told her, and I'm not saying it happened here, but told her, I changed my mind, I'm not going to fire you. I had been thinking about it, but I made a decision not to. And then gets the EEOC complaint, and then says, that does it, I'm firing you. That would be retaliation, would you agree?
Yes, sir.
Okay. So in this case, we don't have a situation where the warden said, I've decided I'm not going to fire you, I'd previously decided, but we do have comments like, we're a great team, let's move forward and do great things, that, it seems to me a jury could infer from that the warden had made the decision at that meeting that she wasn't going to fire her. Because why would you say those things if you're going to fire the person a couple days later?
Because why would you not say it, Judge? Because they were discussing somebody who is no longer at the institution?
Yeah, but why I'd say we make a great team? I mean, it does seem that the more likely, if you'd already decided to fire, the more likely statement would be, no need to go to your desk, you're going to be gone in a couple of days, as opposed to, we make a great team, we'll move forward. That seems more consistent with, a decision not to fire her, frankly.
Judge, I don't know that I have any station to argue.
But either way, I'm just trying to figure out how that's not a jury question, how a jury couldn't reach that conclusion, right or wrong, that the warden had decided not to fire her as of August 19th or 17th or whatever it was.
Because number one, the warden testified without contradiction.
But the jury doesn't, but if you use that argument, you could always defeat a retaliation claim by a person simply getting up and say, I didn't retaliate.
Made up my mind.
Well, I mean,
we
don't rely on a defendant's word exclusively in deciding whether there's...
Judge, I absolutely understand, and I understand where the court is in terms of reviewing this record as argued. But I just have to say that absolutely that you can say that you shouldn't have a situation where somebody can just defeat a retaliation claim by saying I'd already made my mind. But the law, the federal law that applies, which is real clear, is that once you've established that the process has been started, then you break that chain of causation.
But can you break the chain by changing your mind?
Yes, you can.
Okay.
And that's where I get to where I was going, which is the undisputed testimony given by the plaintiff is that there was nothing said in that meeting that indicated that.
The second letter that was sent, what did that letter say? When the warden realized that the plaintiff was on probation and wasn't entitled to that hearing, did she simply say, I revoked my first letter?
Yes, sir.
It didn't say that termination is still on the table or any sanctions are still on the table. It
No,
just said, I
no.
revoked the first letter.
Revoke the first letter to the extent that you do not get a predetermination hearing.
Did it say that?
Yes, sir.
Okay, that's what I was asking. What was the language in there? Did it say, I'm revoking that first letter only to that limited extent?
Just if I could.
It said, I think.
Judge, what it said, and it's Exhibit 9, and what it says is that this is to inform you that the Permanent Career Service Predetermination Conference Letter dated July 1st, 2013, and mailed to you via certified mail 7th, and then it gives the number, is being rescinded, period. You are currently in probationary status as a chaplain, FC.
Okay.
And that's all that was changed, was that, in terms of the process, never the decision. And again,
Well, even the first letter didn't say termination. Didn't it just refer to possible discipline? I mean, discipline could be less than termination, right?
Judge, I don't have that one.
Okay.
But it does in fact say that a recommendation for termination has been made, and that the recommendation, and that you are entitled to a predetermination hearing. And Judge, we're not, and again, this is, please, I want the court to understand, I'm not saying for a minute it's my station to argue the fact that the standard of review is de novo. But with respect to what the record shows in terms of what's going on is that the very nature of the title, a predetermination meeting, is it's something that's required by Loudermill. And basically it says if you have a property interest and you're not going to get your evidentiary hearing before you're escorted off the property, then you have a right to come in and give your side of the story if you want to. And the fact of the matter is, again, our focus is on the fact that that doesn't alter that subject to the approval that there was a decision made to terminate this person, and the only thing that changed that was relevant was the fact that it was discovered that she was on probation, on a disciplinary probation, and therefore there was no need for a predetermination hearing, and nothing with respect to the approval process or anything, because at that point it became complete. And with respect to the issue, Your Honor, it's the position of the appellee that this is a case where the court very, very intently reviewed the record and applied the correct process, and we believe made the right decision with respect to the issue that summary judgment was properly granted. In the event the court disagrees with that, then with respect to the issue of whether or not there had been an exhaustion of remedies, there isn't any question in our mind with respect to the applicable law, and the fact that in this case there's nothing to indicate, including the position taken by the plaintiff in this litigation, that there was anything other than a separate charge that should have been filed before and was not timely filed. Thank you, Your Honor.
Thank you.
May it please the court. I'm going to try to address everything that was done as quickly as I can without stumbling over myself. First of all, opposing counsel indicated that the discrimination claim based on race was never brought. That is incorrect. In the federal case that was filed by my predecessor, who I don't know, it was case number 814 CV 3160, filed December 19th of 14. It was in fact brought. So I would just put that out there to be clear.
That was in federal court?
That was in federal court, right. So what had happened in this case was, and I would say that to some extent opposing counsel is correct in that to pursue Title VII claims, specifically Title VII, not Florida Civil Rights Act, the lawsuit must be filed within 90 days of the plaintiff's receipt of the dismissal letter from the EEOC. When I was brought onto the case and reviewed the file, I did observe that the charge was beyond the 90 days, that the Title VII claims, in my professional opinion, could not stand, and I could not argue it reasonably. So under my ethical obligations, I chose not to pursue Title VII, which left us with the Florida Civil Rights Act. So that's why it was brought then in state court. In any event, to say that there was never a discrimination claim is just wrong.
And state court is one count.
Correct, and that's the retaliation. I would also like to add, and Your Honor noted, in the complaint, paragraph 18, this is at page 13 of the record, Ms. Davis alleged that she exhausted all the administrative prerequisites to her FCRA claim, and in the answer, which is at page 20 to paragraph 18, the response is without knowledge. It's a little more fancy than that, but there's no denial on that front. Okay, the next issue was whether the second letter had some kind of limited extent language. It did not. I've read it, but I can read it again for the panel. Opposing counsel read it, and it does not in any fashion say, we're only saying you don't get a predetermination conference, we are terminating you anyway. It just says, we're taking that letter back, we're rescinding it. Period. Done. No indication there. I would also like to go to Your Honor's point about what happened during the meeting with the warden. Now, this can be found at page 298, starting at 298, in the record on appeal, and I'd like to just briefly read an excerpt. This is from Ms. Davis. And so, Warden Tina Roberts, we discussed the situation with Trevino, and because I asked her, I said, well, what about the situation with Trevino about the letters and all that kind of stuff that came in the mail, these forms that you're talking about? Answer. She said, well, Trevino is gone, so let's not worry about that. We got a good team here, the three of us, herself, the new assistant warden, and myself. Let's make this program shine. Let's just go at it and do a great job. And Ms. Davis says that multiple times. Her story has not changed in that respect. And so, yes, I think it's entirely possible and very likely, based on the documentation, that the warden, if there had been some kind of decision made, changed her mind, which she's certainly entitled to do. Now, here's the part that I would say is part of the error in summary judgment is I can interpret it that way, and opposing counsel can respectfully interpret it a different way, but that's not the circuit court's job to determine who's right. It's the jury's job. I would also like to add that for the court's convenience, pages 431 to 33 in the record has a table that I created for the circuit court's consideration of factual disputes that were just some picked out of the record that are very relevant. And I do want to be clear that, again, the procedural technicalities of whether a box was checked or a second charge was filed, that's not the spirit of the law. That is not what the 11th Circuit has upheld. The standard is, would a reasonable EEOC investigator, would the claim reasonably have arisen from the original charge? And because that investigation was still open at the time of Ms. Davis's termination, it had just begun, it certainly is completely reasonable to suspect that Ms. Davis would have mentioned the termination, would have said it was in retaliation, that these facts would have come to light, and the Department of Corrections would have had an opportunity to address them. They would not have been caught unawares. And in fact, Ms. Davis did expressly mention the termination following the August 17th charge. The morning of August 19th, she comes into work from her leave. Everything is fine. We have this conversation with the warden. That afternoon, Ms. Davis comes back and says, I just, in full disclosure, want you to know I did this. On the 20th, she brings the letter that was inadvertently put in the wrong box. And the 21st, she's terminated. She's not terminated on the morning of the 19th. She's terminated after two separate indications of the charge of discrimination. And for those reasons, I respectfully request that this court reverse and remand with instructions to go to jury. Thank you.
All right, thank you. Thank you both. We'll be in recess.